Hi, everybody. For those of you that were not able to attend class today, I want to give you a rundown on defendants' rights and an overview of the protections that we have in place for people who have been accused of crimes so that there is a prevention of the abuse of power of the government against these individuals. And it's important to note that defendants' rights are put in place to make sure that civil liberties are not eclipsed by the need for social order and security. And specifically, if we look at the Bill of Rights, roughly half of it exists to protect defendants' rights and rights of the accused. And there are protections at every step of the process, from gathering the evidence against you, how that evidence is collected, if you have to testify against yourself, if you have the right to an attorney, how trials should be held, and if found guilty, what your punishment can be. So this chart here in your notes shows, again, from the stage of crime, arrest, prosecution, trial, verdict, if guilty, what protections you have. So we'll be looking through the Fourth Amendment, protection against unreasonable search and seizure, a guarantee that you have a writ of habeas corpus, meaning that you can't be imprisoned without being informed that there's some evidence against you, the right to be informed of the rights that you have while you're arrested. You don't have to say anything. You have a right to counsel, things like that. So steps at every level in every stage of this process. We're going to begin by looking at searches and seizures and your Fourth Amendment rights to protect you against an unwarranted search and seizure. At the root of the Fourth Amendment is a guarantee and a protection that authorities have to have a good reason to suspect a crime, ask for a warrant, have probable cause to be either able to gather evidence against you. So looking at this political cartoon here, you can see that. Now, we have a crash course video on searches and seizures. I'm going to ask that you find it and that you watch the crash course video and answer the questions that follow. For you, you can either find the video linked in the daily agenda slide, or you can find it linked in Canvas. Okay, so in that video, lots of ground covered on some of the key pieces here. Mapp versus Ohio, very important case that helped lead us to the exclusionary rule, where it says that you have to have evidence that is lawfully, legally obtained. It has to have come through probable cause, meaning that there was some way that we knew that we had to gather that evidence. Search warrants, important, that there is enough evidence that you can justify the request to legally search for something. Now, as we saw, there are lots of cases, there are lots of exceptions to this, but the exclusionary rule established by Mapp versus Ohio in 1961 was a very, very important case. Some of the common exceptions to the exclusionary rule would be that evidence that could have been obtained legally and the police didn't know that the seizure was improper. A lot of times judges will let slide, meaning that we could have maybe found it with alternative means. Evidence that is found in plain sight, maybe not on the warrant, but was just out in gathering other evidence is okay. And if the police can prove that they were operating in good faith when the evidence was found, a lot of times they'll allow that to stand. Now, there have been some constitutional questions, and again, this debate between your personal rights and liberties and order and safety and security for everyone else. And the war on terrorism has definitely kind of tested on that. A lot of times acting almost outside of the Constitution. The U.S. Patriot Act that was passed in 2001 allowed the government new powers of surveillance to find terrorists, and they were essentially able to gather whatever information they would need through any means, wiretapping records requests, without needing a warrant to do so. And at the time it was passed, Americans were willing to accept this in the name of safety and security. Again, looking at 2001, right? This is right after 9/11, but questions on how much of an invasion of privacy there is, how companies and corporations civilians can gather data on civilians, on citizens today, but a lot of times we click that right away when we accept cookies or terms of agreement. But there's still ongoing conversations about that appropriate balance of how much of an intrusion is it actually. Next, we're going to look at self-incrimination. This is found in the Fifth Amendment. Essentially, this defines the burden of proof to be on the prosecution. And what we mean by that is that you are innocent until proven guilty. You do not have to testify against yourself. You do not have to help the prosecution prove your guilt. You can remain silent. You don't have to offer up any information. It is up to the prosecution to build a case that proves without a reasonable doubt that you are guilty of that crime. One case that's important to mention with self-incrimination is Miranda versus Arizona in 1966. This case defines our Miranda rights. You have the right to remain silent, informing whoever you are arresting and taking into custody that anything they say can be used against them, that they have a right to remain silent and not say anything, that they have a right to request an attorney be present during questioning. They don't have to answer their questions on their own. And if you cannot afford an attorney, one will be provided for you. Here's just a screen grab of the Miranda warning. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. And then it is required that the officer reading the Miranda rights asks for confirmation that the rights have been read, that they've been understood. And in that moment, then it's up to the individual to decide if they wish to speak to the officer or wait until an attorney is present. The Sixth Amendment then deals with the right to counsels and trials, and specifically the Sixth Amendment guaranteeing the right to an attorney. But we've talked about the concept of incorporation, and this right was not something that was universal. This, remember, was a right that initially applied only to federal cases. So the Sixth Amendment guaranteed a right to counsel in federal courts, but most trials happen at the state courts, and most defendants could not afford an attorney. So what happened was this question then of, well, what happens when a person is convicted of a crime or going to be convicted in the process and can't afford an attorney? In 1932, it was incorporated to the states. The states had to pay for an attorney if a crime was a capital offense, meaning that it was on the table that a person could get the death penalty. In 1963, through this important case, one of our required SCOTUS cases of Gideon v. Wainwright, this was extended to include that the federal government, that right incorporated to the states. States had to pay for attorneys for anyone accused of a felony. So an indignant is somebody standing trial, somebody unable to afford an attorney themselves. So I want you to pause here and then read that case of Gideon v. Wainwright in your case packet.